The Philippines joins the growing list of countries that include Russia and South Africa that are withdrawn from the International Criminal Court. The reason? These supposed baseless accusations against President Duterte over alleged extrajudicial killings. Now, whether the withdrawal takes effect immediately or 1 year after the signification of the withdrawal is still up for debate. But tonight on this episode, we ask our debaters, is the Philippines' withdrawal from the ICC constitutional in the first place? I'm Mike Yoreta, and you're watching Square Off, Season 15, The Firm Debates.
Another shocker from Malacanang this year. President Duterte pulling the Philippines out of the International Criminal Court, which investigates war crimes and crimes against humanity. The president cites what he calls are baseless, unprecedented, and outrageous attacks against him by UN officials and the ICC's attempts to place him under its jurisdiction. A stark difference from the president's reaction back in February.
If you want to find me guilty, go ahead. So be it. If you hail me into a rigmarole of trial and trial, no need. Go ahead and proceed in your investigation.
The ICC has begun its preliminary examination of Duterte's bloody drug war. The president says the ICC cannot have jurisdiction over him, given the Rome Statute, which created the ICC, was never published in the Philippines, a requirement for a law to be effective. The move drew mixed reactions.
Parang ang na-feel ko dyan, parang takot na takot sila eh. No? Eh bakit kung wala kang tinatago, ba't ka matatakot?
Ang feeling ni Presidente, loko lang pala kami. Hindi nyo naman pala kami, hindi mo nire-respect yung aming mga saligang batas at mga batas namin.
What you simply have is a clear pattern of emotional reactions triggered by whatever the president feels at the moment.
Delikado ito sa future generations. Kasi paano kung naging mapang-abuso yung nakaupo, wala na tayong malalapitan. Yung pagiging signatories natin sa ICC, parang safety net.
The president's spokesman, who once praised the ICC, warns the Philippines' withdrawal is the beginning of the end for the ICC.
Wrong political move, Madam Prosecutor, and I'm addressing you wherever you are. You are to blame if ICC becomes part of the dustbin of history.
The International Criminal Court's head of management oversight and legislative body, meanwhile, is asking the president to reconsider his decision. So, is the Philippines' withdrawal from the ICC constitutional or not?
Arguing for the affirmative side is Mindanao State University. From the institution that believes in unity through justice, the next generation lawyers from Mindanao State University.
I can easily adapt to people and I can easily make friends with a lot of people. As cliche as it sounds, but I take up law school because it has been my childhood dream, and this is also my mother's dream for me, and I want that to become a reality.
I took up law because mainly it stemmed from curiosity of what the law is, because before law school I know so little about it. And then it developed into an interest, and right now I am enjoying my law school experience.
I took up law because I'm a believer of John Adams' statement that we are a nation of law, not of men, and I think the best way to uphold the rule of law is through legal education.
Team Mindanao State University. Strong, resilient, resourceful. And taking on the negative side is San Beda University. Committed to the battle for the greater good, the Red Lions from San Beda University.
I took up law school since when I was in college, maybe when I was a kid, I think it was more of a calling for me, helping people out, helping the ones in need, especially in our country right now. And more than that, of course, helping my family.
My best personality, I think, is the resilience and the ability to cope with whatever stress or struggle I might experience in law school. As being a law student, it is very important that I learn how to manage my stress or my emotions well, so that I can objectively try to see or to study or even to make sense of the situation that I'm currently in.
I don't just want to be a lawyer when I eventually pass the bar 4 or 5 years from now. I want to be a really good lawyer. I took up law school because, probably because of my undergraduate degree. I was a pol-sci major and I really like legal topics. I suppose it's because of the love of law and legal subjects.
Team San Beda University. Wise, humble, committed. Let's now meet our distinguished judges. First off, we have attorney Monica Ciron, a senior associate at the V&A law firm. Next, we have attorney Chris Lau, faculty member at the DLSU College of Law. And presiding as our chief adjudicator this evening is Judge Mervin Jovito Samadan from the Regional Trial Court, Branch 40 in Dagupan City. We're using a modified Oregon-Oxford format. The debate is between two sides, the affirmative and the negative, with 3 members each. Each debater from the affirmative side argues the necessity, beneficiality, and practicability of the proposition, while the counterpart debaters on the negative side oppose these arguments. Each debater is given 4 minutes to deliver a constructive speech and rebut the previous argument. Each debater is given 2 minutes to interpolate or cross-examine the opposing debater. Only categorical questions may be asked. Each of the judges may ask 1 question of each speaker within that speaker's time limit. The judges score each team in terms of manner, matter, and interpolation. The team with a higher score from each judge gets a point. The team with the most number of points wins the debate. The chief adjudicator rules in the event of ties, objections, or contestations. Tonight's proposition: let it be resolved that the Philippines' withdrawal from its membership in the International Criminal Court is unconstitutional. First up, for the affirmative side, we have Vogue. Vogue, you have 4 minutes to tell us why we need to consider the withdrawal from the ICC as unconstitutional.
The Senate's concurrence in treaty withdrawal is dictated by democratic norms and constitutional principles. It makes sense on legal, policy, and political levels. May it please your honors, fellow debaters, ladies and gentlemen, good evening. The Rome Statute of the International Criminal Court was established in 1998 to help end impunity for perpetrators of serious international crimes such as genocide, war crimes, crimes against aggression, and crimes against humanity. Then President Estrada signed the Rome Statute in December 2000. In August 2011, our Senate made the required concurrence. However, on March 14, 2018, President Duterte made a pronouncement of the Philippines' withdrawal from the Rome Statute effective immediately. The unilateral withdrawal became contentious as a monumental issue arose, whether or not the withdrawal from the treaty requires Senate concurrence. Your honors, the affirmative humbly submits that there is a need for Senate concurrence in treaty withdrawal and that it is necessary to declare the unilateral withdrawal made by the President as unconstitutional based on the following points. First, unilateral withdrawal contravenes the governing principles of governmental powers. Second, Senate concurrence is in keeping with settled principles of constitutional construction. Indeed, the President is the chief architect of our country's foreign affairs. However, this debate is not a question of the soundness or the wisdom behind the withdrawal of the President, but rather a question of compliance to constitutional requirements when it comes to treaty withdrawal. Section 21, Article 7 of the 1987 Constitution provides that no treaty or international agreement shall be valid and effective unless concurred in by at least 2/3 of all the members of the Senate. It does not speak, however, of withdrawal. While it is true that the Constitution is silent on whether or not congressional concurrence is needed in order to validly revoke or withdraw from a treaty, it is also equally silent as to whether the President has the constitutional power to unilaterally withdraw from a treaty. Implicit within the separation of powers doctrine is a recognition that any governmental decision made by the concurrent will of the President and the Senate constitutes a more authoritative and democratic act of governance than is possible where the President is to act alone. The force of this proposition is no less evident when the subject is treaty withdrawal. The cases of U.S. versus Nixon and the New York Times versus U.S. are instructive. These cases held that when the Constitution is silent with respect to a governmental power, it implies that such power is shared by the branches. As the plain meaning rule and the intent of the framers of the Constitution cannot apply in interpreting the silence of Article 7, Section 21 of the 1987 Constitution, the Constitution must be interpreted as a whole. As the state interest is involved, constitutional questions should be approached from a pragmatic rather than from a legalistic point of view. This is the prevailing norm of constitutional construction in cases where the Constitution is silent, as applied by the Supreme Court in the landmark case of Polia Manzares versus Comelec. Necessity dictates that the Constitution must be interpreted and understood to be transcendent, evolving, and aspirational in order to pursue a higher constitutional philosophy. The assertion that the President alone has the power to terminate any treaty he finds impolitic reduces the ability of the people to participate meaningfully in the formation of our foreign policy. If the concern is preserving the democratic structure...
Time's up. 2 minutes now for the cross-examination.
Good evening, Bob.
Good evening now.
So, withdrawal from a treaty is not expressed in Article 7 of the Constitution, is it not?
It is not.
It's not, right? So are you aware of the fundamental principle in constitutional construction of casus omissus?
Yes.
Yes, so if you know that, a thing omitted is intentionally excluded, meaning having withdrawals not expressed, it was intentional for the legislative to leave it out. But of course, this is with exceptions, right?
Yes.
Right, when the legislative did not intend to exclude it, right?
Yes.
So, since the validity and effectivity of a treaty were the only things supplied, these are the only intent of the framers, right?
There was no intent by the framers of the
No
Constitution
intent of the
because
framers.
of the
No intent of the
Constitutional
framers. Have you
there
read
was
the
no
Constitution?
mention about the withdrawal.
Counsel, it's my time. Did you read the 1986 Constitutional Commission deliberations?
There was no mention about the withdrawal
No
in the
mention
deliberation.
without the withdrawal.
Yes.
Exactly, Your Honor. Since there
And
was
it is
no
equally
mention
the
without
same
the
silent
withdrawals,
as to the
meaning
unilateral
there was
withdrawal
no
by the
intent in
President.
the first place. Next question, Bo. So, you agree that the President is the head diplomat of the state,
Of
right?
course, there's no issue about
So
that.
he has the authority to recognize states and enter into treaties.
Of course, yes.
Of course. So are there unstated powers which are implied from the grant of executive powers?
Remember that if we're going to allow the
Are there?
President
Yes or no?
then
Yes
it's
or no?
going to be a
Yes or no?
violation of the
Yes or
principle
no?
of checks and balances.
Have you read the case of Marcos versus Manglapos?
Yes.
Yes. So in that case, basically, the Supreme Court held that the powers of the President are not limited to what are
Remember that the
expressly
facts of that
enumerated
case are not the
in
same as
what
with this
the
one.
executive department has. Meaning, he has implied executive power to these withdrawals.
There's
in the
no
first
problem
place.
about the executive
Vote.
prerogative.
Next question. Basically, you say that there should be separation of powers, checks and balances.
Yes, of course.
Right. So, is the express provision of a treaty being valid in Article 7, Section 21 is a checks and balance principle?
If we're going to construe the entire Constitution,
Basically.
it will lead us to the
Next
principle
question.
of
Next
checks and
question.
balances.
Okay, Chris, you've got 4 minutes now to advance your argument and tell us why we must not consider the Philippines' withdrawal from the ICC as unconstitutional.
Your Honors, one of the basic principles of constitutional construction is casus omissus. What is omitted is
Stay lang tayo,
intentionally
ikot-ikot
excluded.
lang hanggang
When the
sa
1986 Constitutional Commission did not
use your
expressly
tankest,
provide
ano,
the exercise
use
of
your
power of
tankest
treaty
na-
withdrawals, they did not really forget about it.
Ano?
But they
Tankest
intended
na frame.
not to include it.
Kasi sobrang
Since
hirap.
the 19th
Kahit
century,
naka-rhino
almost
skin,
all
one hit
actions
lang.
to withdraw from treaties was done unilaterally by the United States through the President and his or her agents. With this line of history,
Tsaka
Your
no
Honor,
use pala yung weapons
teams have
against
made us
sentients
convinced
kasi
there are
di
two
ba nga
instances when a
nadaan sila
unilateral
kagad.
withdrawal
So,
of the executive can be deemed unconstitutional. First, when there is a procedural defect, such as in the case of Goldwater versus Carter, a case decided by the United States Supreme Court, absent an issuance of a Senate resolution denouncing the unilateral withdrawal, the act of the president stands. And secondly, is when there's a grave abuse of discretion, as when the decision of the executive was made in a whimsical... Yes, Your Honor.
Mr. Speaker, are you saying that the power of the president regarding foreign policy is absolute in accordance with the Constitution?
Basically, Your Honor, we acknowledge that the president's power is not absolute with regard to foreign policy, but with regards to the Constitution and our domestic laws, we say that he has certain kinds of powers, implied powers, and these are residual powers. Wherein, in the case of Marcos versus Manglapos, these powers are basically when it's not in the legislative, when it's not in the judiciary, then it's in the executive for the president to exercise. Basically, Your Honors, for the affirmative side to be successful, first they must overcome the presumption of constitutionality, and second, they must achieve in overcoming that there's a grave abuse of discretion, since there's a high bar that must be proven, otherwise this discretion is presumed to be within the bounds of the Constitution. Two levels of analysis for non-necessity. First, with the inherent executive power of the president, he has the discretion to withdraw unilaterally as chief architect of foreign policy. Your Honors, the president is authorized under the Constitution to deal with foreign states and governments and enter into treaties as held in the case of Pimentel versus Executive Secretary. The wisdom behind this, Your Honor, is the president is the steward of the people and has the duty to protect the general welfare. Given these main diplomatic duties of the executive, the powers of the president are not limited to what are expressly enumerated in Article 7 and in scattered provisions of the Constitution as held in the case of Marcos versus Manglapos. Applying these cases in today's debate, given the absence of the provision in the Constitution regarding the withdrawals from treaties, the withdrawal from the International Criminal Court is not necessarily unconstitutional, as it is part of the executive authority pursuant to his inherent executive powers in which he had acted upon. Well, in fact, Your Honors, Justice Brennan opined in the case of Goldwater versus Carter that since the president possesses the right to recognize countries, he consequently has the legal authority to unilaterally withdraw from a treaty. Second, even if we assume it's not inherently executive power, we follow the principle of casus omissus. What is omitted is intentionally excluded. If we look upon the records of the 1986 Constitutional Commission, there was no discussion regarding the power to withdraw from treaties. Your Honors, it will be very dangerous to read what the framers did not include. That is why when the provision is absent, it is presumed that the framers actually intended not to include such, but to fall consequently. Yes, Your Honor.
Mr. Speaker, is it your position that, assuming that the president has those residual powers that you're talking about, is it your position that the manner by which he is in fact withdrawing from the treaty, is it constitutional?
Your Honor, we acknowledge that basically the president has his reasons for withdrawing, but these reasons are basically, in terms of international law, are not considered, since basically Article 127 of the Rome Statute only requires him to be given a notification. But considering the grave abuse...
2 minutes for the cross-examination.
Good evening, Mr. Speaker.
Good evening, Counsel.
Mr. Speaker, it is your position that the president can unilaterally withdraw from the treaty, isn't it?
Yes, of course. It's within his powers inherent.
There is no limit in treaty withdrawal because Section 21, Article 7 of the Constitution only mandates concurrence in treaty making.
It's limited only to the president.
However, you confirm that Section 21, Article 7 of the Constitution is silent on treaty withdrawal process.
Of course, that's what I said a while ago. The 1986 Constitutional Commission did
that
not
it does not, Mr.
on
Speaker, that it does not equally expressly confer upon the president the power to unilaterally withdraw.
Not, exactly, because that was the intent of the first.
So you
place,
agree that in deciding
in there.
important issues, we must always consider principles of governmental powers, such as checks and balance,
of course,
separations of powers.
Of course.
Of course. In this case, you agree that applicable construction that is to interpret the Constitution as
checks
a whole.
and balances only applies if there's an express provision. You cannot give any checks and balances.
My question,
if there's no express
Mr.
provision
Speaker,
in the
is that
Constitution.
should we interpret the Constitution as a whole?
Of course, that's basic
exactly.
constitutional
And
construction.
you agree with me that we can likewise seek guidance and reference to jurisprudence of the U.S. where our Constitution is modeled.
That's what I said a while ago in Goldwater versus Carter.
Are you aware, Mr. Speaker, that in the seminal cases of U.S. versus Nixon and New York Times versus U.S., that the U.S. Supreme Court held that when the Constitution is cited with respect to governmental powers, it implies that such power is shared by the governmental branches.
You did not include several
but
cases.
But are you aware
of
that?
Goldwater versus Carter.
Remember that the Goldwater case. Are you aware of the Goldwater case?
Yes, of course. That's what I cited a while ago.
Exactly. The Goldwater case is a broad precedent because it does not resolve the issue.
It's a basically political question.
But you're aware that the court remanded it
resolution.
back to the federal trial court.
Of course, there was no.
So meaning to say the issue was
but the
not
president
settled.
still unilaterally withdrew from
But
the
the
Taiwan
issue was not
treaty
settled, Mr.
because
Speaker.
There was recognition.
Answer my question. Was the issue settled?
What's your question?
Was the issue settled?
It was a political question.
By application, therefore, we can deduce that the silence of our Constitution and treaty withdrawal implies
gonna
that
be
such powers,
gonna
let
be
me
a
finish,
political
Mr. Speaker.
question.
By application, we can deduce that the silence of the Constitution is to the.
Let's now hear from the second affirmative speaker, Ivy. You've got 4 minutes to tell us why it would be beneficial to consider the Philippines' withdrawal from the ICC as a violation of the Constitution.
A unilateral withdrawal of a validly entered treaty is anti-democratic and anti-constitutionalism. Negative's primary argument is hinged on the premise that as the chief architect of foreign relations, the president can solely exercise treaty withdrawal. However, this transgresses the principles of governmental powers and that as the Constitution is construed as a whole, it contravenes settled constitutional precepts. Your Honor, to further bolster our submission with treaty withdrawal requires Senate concurrence, I will articulate the following points. First, it is in consonance with the checks and balances among the branches of government. Second, Senate concurrence promotes democratic norms and prevents an autocratic rule. The first benefit is the conformity to the fundamental checks and balances in the co-equal branches of government. It bears stressing that one of the main functions of the Constitution is to the assignment of powers with said system of checks and balances. As eloquently said by the Supreme Court in Angara versus Electoral Commission, the Constitution has provided for an elaborate system of checks and balances to secure coordination in the workings of the various departments of the government. The best example is the lawmaking process under our Constitution. The President may sign or veto a bill passed by the Congress, in the same manner that the President's veto may be override by the Congress. And in this context, entry to a treaty requires 2/3 votes of the Senate. If there is a constitutional safeguard in entering into a treaty to ensure that the provisions thereof are not detrimental to the interests of the state, how much more upon withdrawal from it when governmental interests are already implicated? In the Rome Statute, such governmental interest is reflected in the Senate's concurrence to the Rome Statute embodied in Resolution Number 57, which is commitment to human rights and contribution to an effective international criminal justice system. And finally, to hold that Article 7, Section 21 of the Constitution does not require congressional role is a dangerous precedence. It will confer upon the President an unbridled or expansive power which is not only anti-democratic but anti-constitutionalism. If we allow the President to be unchecked upon his withdrawal from treaties, how do we ensure that he will not abuse his power? How do we limit his power? While we concede that the President is the chief architect of our foreign policy, this does not mean that he can disregard the other equal branches of government. Inclusion of the Senate in the process of treaty termination democratizes the decision to terminate such international compacts and ensures that there is representation of the people's will regarding the matter in a manner consistent with the treaty creation process. This will avert our country from personalist dictatorship, an authoritarian system of social repression set by an individual such that all policy dictates derive from him. Your Honors, Article 2, Section 1 states that the Philippines is a democratic and republican state. For us to remain as such, we must therefore construe the Constitution in a manner generally aligned with the purposes of democracy and republicanism, which means people representation in government and not individual prerogatives alone must dictate the course of our nation. Thus, it is more beneficial to construe withdrawal from treaties by the executive with Senate concurrence. Thank you. I am now ready for the interpretation.
Okay, 2 minutes for the cross-examination.
Good evening, Counsel.
Good evening.
So is it your position then on your side of the House that if the withdrawal is done by the President alone, that it amounts already to an abuse of his discretion?
Yes.
Yes. So you're saying that if a person, a single person, is already vested with that power and he exercises that power, then it amounts already to a grave abuse of discretion. Is that automatic?
No, because
No,
the Constitution is
precisely
silent about it,
because
and
there
if
are
we construe the
limitations
Constitution
first
as a whole, there must be
that
checks
must
and
be
balances.
violated before it can be said to be unconstitutional or that there is grave abuse of discretion. Second question now, your counsel. Any act now by the person, so long as vested in one person is not grave abuse of discretion, and the threshold that is set, in this case, was that violated?
Pardon?
The threshold that was set, in this case, was it violated?
What we are questioning here is the mechanism
Just
by which
yes or no,
by the
counsel.
president,
Just yes
by
or no.
which the president effected his
Counsel,
withdrawal.
yes or no?
Again, the question:
Was the threshold violated?
what threshold?
Okay, seeing that you cannot understand or grasp my question now, I'll just move on to the second question. You said a while ago that the concurrence serves as a form of checks and balance, right?
Yes.
This is primarily hinged on your argument that by implication it should be granted to the Senate, right?
As a general, as a
Yes or no?
construction
Just
of the
a simple
Constitution.
yes or no, counsel.
Yes.
Okay. So are you saying now then that the treaty-making powers of the president can be limited by mere implication?
No.
No, it cannot be limited by mere implication. So you are self-destroying yourself already because your
No, we must
presupposition
consider the
is that it was
Constitution
not
Council as a whole.
It is my time. That it is not granted and therefore it is merely implied according to you, so because we have to apply constitutional construction. So it is never expressed. It's only implied.
Likewise, in your case,
And
counsel,
have you read
unilateral
the case of
withdrawal is not
Garfield?
implied.
All right, Jed, you've got 4 minutes now to rebut Ivy and advance your argument on why it would be beneficial to consider our withdrawal from the International Criminal Court as constitutional.
The right to enter into something must necessarily come with the right to exit. Your Honors, when the President is authorized to enter into a treaty, he must necessarily be given the right to withdraw from it. Responding to the arguments of the affirmative side, we on the negative side submits that the power of the President to exercise such discretion to withdraw will never or will not amount to a grave abuse precisely because there are thresholds. And that is first, there must be the limit to which grave abuse of discretion must first be violated. And what is that limit? That it must not be based on any legal justification at all. The President in this case has legal justification on the matter, and on that score alone, the case of the affirmative must fall. Proceeding now, Your Honors, the requirement that Senate concurrence must be made before withdrawal creates two disbenefits. First, it erodes the separation of powers, and second, it infantilizes the treaty-making power of the President. For the first disbenefit, Your Honors, the power to ratify treaties is vested on the President, being the chief architect. And upon ratifying, it already binds completely the country to any international obligation, regardless of whether or not there is Senate concurrence, as provided under the Constitution. To grant then the Senate the power to partake in the decision to withdraw would mean that their decision is a precondition. When the Senate's decision affects whether we can withdraw or not, it transforms them into a co-architect in our foreign policy. This is because one cannot act without the other. The harm now exists in the sense that Senate can now override the decision of the President on matters which should have fallen under his exclusive executive power when it comes to our foreign relations. It now renders nugatory the role of the President in our foreign policy, and therefore Senate is now wielding executive powers that is contrary to the doctrine of separation of powers. This now, yes, Your Honor.
Mr. Speaker, will there be any domestic laws that will be affected by the withdrawal of the Philippines from the ICC?
Your Honors, in this case, we submit that although there are a municipal law that was enacted, still that municipal law is a separate product of the legislature and not based on or not dependent upon the existence of the treaty. The second disbenefit, Your Honors, is that it infantilizes the treaty-making power of the President. The U.S. Supreme Court has provided that over the years, there are instances that the president's withdrawal without Senate concurrence is upheld. And in this case, applying it to the Philippine Constitution, the wisdom is that the president is exclusively positioned to acquire information and weigh the same to balance our local interests with that of other nations. The harm exists when the president ratifies a treaty and after due assessment, it has been considered non-beneficial to the state. Here, he cannot easily withdraw because without the required Senate concurrence, the state is bound to comply with what it deems to be a non-beneficial treaty. The ultimate effect being that the president's treaty-making power is infantilized because he may hesitate to form binding treaties with other states for fear of not being able to withdraw once the treaty becomes non-beneficial, and thus it renders hostage the treaty-making powers of the president. Taking all of these circumstances together, Your Honors, we submit that the harms of declaring the withdrawal as unconstitutional results from the violation of the separation of powers and infantilizing the President's exercise of his treaty-making powers. As a conclusion then, maintaining such withdrawal preserves the doctrine of separation of powers and allows the President to fully exercise that treaty-making power.
2 minutes now for the cross-examination.
Good evening, Mr. Speaker.
Good evening.
One of the aim of the Constitution is the assignment of powers to the three branches of government, is it not?
Yes, we concede to that fact that there is indeed separation of powers.
Okay.
Separate powers are given to the separate
And
departments.
am I correct to say that along with the assignment of powers to the three branches of government is a system of checks and balances?
Yes.
And do you agree with me that the idea of checks and balances is to secure coordination among the branches
But
of
Counsel,
government?
again, you're operating on a wrong premise because for checks and
Next
balance to
question.
provide...
And is checks and balances a democratic norm?
Yes, we agree to that fact.
Now, Mr. Speaker, the idea of Section 21, Article 7 requiring concurrence to render a treaty valid and effective is to reinforce checks and balances. Is
Yes,
it not?
we agree to that fact.
And Mr. Speaker, in the same manner, withdrawal from a treaty with Senate concurrence is more in consonance with fundamental principles of the Constitution.
No, it's not. Because the difference there lies, Counsel, in that to ensure that we are not shedding off more than part of our sovereignty when we enter into
Did
a
I get
treaty
right, Mr. Speaker, that you are of the opinion that unilateral withdrawal from a treaty is more in consonance with checks and balances?
No, we're not saying that, Counsel. What we are saying is that you're operating again on a wrong premise. That in providing for a checks and balance in
Again,
entering, it is
another
merely
question,
because
Mr.
we are
Speaker.
we must safeguard on
In
shedding off
principle,
more the
Mr.
sovereignty
Speaker,
on
it
what
prevents the system of checks and balances prevents or precludes abuse of power, is it not?
Yeah, sure. No
Yes.
one would say no
And
to that.
the prevention of concentration of powers in one branch of government, thereby avoiding abuse of power, is the bedrock of democracy.
Sure, we could agree to that.
Therefore, if we give the powers to the president, the power to enter into and the power to withdraw, isn't that without the statement or the provisions from the Constitution, isn't that giving him too much power?
Of course not, because as we said a while ago, there is a limit or there is a threshold that must be met first.
Thank you, guys. Let's now hear from the third affirmative speaker, Jan. You've got 4 minutes to argue the practicability of considering the Philippines' withdrawal from the International Criminal Court as unconstitutional.
As Madison once stated, the accumulation of all powers in the same hands may just be the pronouncement of the very definition of tyranny. 2 key points why Philippine withdrawal from its membership in the ICC is practicable to be declared unconstitutional. First, because unilateral withdrawal contravenes Section 2, Article 2 of the Constitution. Second, Senate concurrence stimulates consistency in our foreign policy. The Constitution is not an end in itself, but rather a means to some higher ends, and the purposive approach to constitutional construction has sought to implement the basis and the basic purpose of our system of government. First point, unilateral withdrawal contravenes Section 2, Article 2 of the Constitution that embodies the incorporation of the generally accepted principles of international law as the law of the land and our policy to adherence to the preservation of peace, equality, justice, freedom, cooperation, and amity with all nations. Our membership in ICC best depicts our adherence to those constitutional values. Moreover,
Article 54 of the Vienna Convention on the Law of Treaties prescribes that withdrawal from a treaty may only take place in conformity with the provision of the treaty. But in the case of President Duterte's withdrawal from Rome Statute, as reflected in his letter to United Nations Secretary General, was anchored on the ground that the withdrawal clause or Article 127 is not applicable for the reason that there appears to be fraud in entering into such agreement. Political reason even dictate that treaty withdrawal is a concurrent power. Without a congressional check in this area, the president holds a massive power to affect unilaterally Philippine international commitments and obligations with potentially dangerous and precarious effects. Giving the president unfettered power in treaty withdrawal unduly increases his power in our government structure, and it goes against the function of the Constitution. Second reason is that Senate concurrence stimulates consistency in our foreign policy. A treaty is a contract among and between nations. Our action in terminating a treaty reflects on our commitment to international law. Subjecting a treaty withdrawal to the same stringent mechanism as treaty creation process establishes a clear method which other states will perceive as a strong foothold. It will encourage other countries to confidently engage in treaties with us, knowing that we have a stable treaty mechanism and thus treaty will not be capriciously withdrawn. The participation of the Senate as a collegial and more continuous body in a treaty withdrawal will aid in consistency of our foreign policy. In this case, our commitment in the international rule of law by being a state party in the Rome Statute. In De Castro versus Judicial and Bar Council, Associate Justice Arturo Brion explicitly articulated that the principle of constitutional interpretation militate against an interpretation that would give primacy to one branch of the government over another. Each branch of government is in place for a particular reason, and each one should be given every opportunity to operate to its fullest capacity. Yes, Your Honor.
Mr. Speaker, would you agree with me that it's exactly practicable for a state party to withdraw from something which it the principles of which it no longer upholds, like in this case?
No, Your Honor. It should be the Senate concurrence is very important in this case. Proceeding on, we argued from the affirmative that the reason why it is unconstitutional because it contravenes governing principle of the governmental powers.
All right, 2 minutes now for the cross-examination.
Good evening, Counsel. Good evening. Would you agree with me that concurrence is a limitation on the power of the President?
Yes.
And wouldn't you agree that if it is a limitation, then it must necessarily be expressed?
Yes.
Yes, but
not necessarily.
Not necessarily. So which is it really?
Not necessarily.
Not necessarily. Even if in the case of Garafil versus Office of the President and Sarmiento versus Mison, those two cases expressly stated that an inherently executive power, the limitation to those must be expressly stated. Would you rather go against these two jurisprudence? Would you rather go against these two jurisprudence?
Yes.
Yes?
Yes.
Are you sure? Okay. If that's your, but would you agree with me that before the Senate concurs, there would probably be proceedings, right?
Of course, deliberation.
And before the deliberations, like, and they take in information, obviously.
Yes.
But would you agree with me that the President has information which the Senate has no right or access to?
The Senate also have information which the President doesn't have right.
Are you sure even if the President is in the most opportune position to actually acquire this position, this information?
No, it's
and
check and balance.
Information,
both
right?
have separate powers. They both possess
also,
equal power.
You would rather the Senate have a say in the international relations, even if they are not the chief architect of foreign
Remember
policy?
that the role of the President is not absolute.
You know what? I'm just gonna take it as you're doing that you're biased against the Senate.
No.
Anyway, would you agree with me that all cases of sharing of powers are in the Constitution?
Yes.
Yes. And again, there's no express provision about concurrence in the Constitution.
Exactly the reason why we need to interpret it into government principles of check and balance and separation of powers.
No, Counsel. Every single provision about the blending of powers or sharing of powers are in the Constitution, right?
But if it's silent,
okay,
we
fine.
need to
Can
be
you
able
think
to make
of
sure.
any limitation on the inherently executive power that is not expressly provided in the Constitution? Apart from this one, of course.
There isn't. However,
There isn't
this is a
exactly,
landmark
because
case.
it
We need
has
to
to
be
be
able
provided
to
first in
interpret
the
the Constitution for the benefit of the majority.
Okay, Joanna, you've got 4 minutes to rebut Jan and advance your argument on why it would be practicable to deem our withdrawal from the International Criminal Court as constitutional.
Thank you. Your Honors, just because something is unpopular does not mean that it is unconstitutional. First, on their idea that the Senate concurrence is that the Senate we need Senate concurrence with regard to withdrawal. The only response to this is the casus omissus already forwarded by my first speaker. If they wanted the withdrawal to be limited, it would have been expressly provided. But moreover, the implication of their entire frame is that it necessarily dilutes it is a dangerous precedent that it necessarily dilutes the separation of powers. Ladies and gentlemen, Your Honors, under our Constitution, the limitation on the executive power is still determined whether or not there is a grave abuse of discretionary power. This is the only checks and balances that we need, because the President is in such position that he has to deal with other states, meaning that he is more qualified than the Senate in doing so. But moreover, when we enter into a treaty, we give up or we surrender that part of our sovereignty in order to gain the benefits of the treaty. This is the pronouncement in the case of Bayan versus Zamora. And to a certain extent, we consider that in this case, we may need some form of checks and balances. But you see, during withdrawal, such is not the case. During withdrawal, we do not shed off a part of our sovereignty. In fact, we regain that part that we have previously surrendered. That's why when we withdraw from something, checks and balances is no longer needed on the first place. But moreover, 2 points coming from practicability. There are two costs in this. There are two costs when we require Senate concurrence during withdrawal. First is time, and the other one is stature. Let me illustrate. Inside affirmative, the process would have been that upon the determination of the harm, the President opens the idea of withdrawing from a treaty because it has to be concurred in, then someone in Senate has to initiate in order to convene, and then the Senate must necessarily convene, and then the Senate gathers information and they debate upon matters, and then they would conduct hearings, exchange of ideas, subpoenas, what have you, before they can finally decide to concur or not. Ladies and gentlemen, Your Honors, this takes months, and there are times when the President has to immediately withdraw from a treaty due to a change in circumstance which makes that treaty prejudicial to the country. Such assessments are based on information unique to his position by the virtue of the powers as discussed in Pimentel versus Executive Secretary as Chief Architect of Foreign Policy. In fact, in the case of Senate versus Ermita, the Senate cannot even coerce the Executive to disclose certain confidential information in their exercise of legislative inquiry. Consequently, what happens is that the Senate therefore cannot make a fully informed and yes, Your Honor.
Mr. Speaker, will there be other treaties that the President should have consultation with the Senate first before withdrawing, or is this an isolated case only?
We submit, Your Honor, that there are treaties which necessarily provides the Senate concurrence is required before the President must withdraw, and because of that, the President therefore must consult the Senate. But such is not the case in the Rome Statute, because when we signed the treaty, it did not provide for the Senate. It did not require rather the Senate concurrence when we entered into the same. Going back to the point, Your Honors, as the process drags on, we incur daily political costs. Your Honors, regardless if the investigation has an established basis or not, what we know to be true and happening is that the investigation derogates the international stature of a state, as in the case of Burundi, Ghana, and South Africa. These are the costs that we are not willing to take. Right now, the country is in a politically sensitive situation. There are issues on territorial claims with China and changing global landscape of superpowers. The international climate is very fluid, and the President has to decide. And when the President has decided that we cannot.
2 minutes for the cross-examination.
Good evening, Council. I would appreciate a yes or no answer.
Of course.
Treaties involve important compact with other states. Is that correct?
Correct.
And that it will affect our international obligation and commitments. Do you agree?
Agree.
Do you agree that Senate concurrence in treaty making helps ensure deliberated and democratic mechanism in impacting our international obligations and commitments?
If you were listening to my argument,
Yes
the
or
answer
no?
is no, because
Yes.
they have very limited information, Council.
Do you also agree with me that our government decision in foreign affairs shapes and affect our character
Of course.
and image in the international community?
Which
Yes.
is exactly why it should be left on the
Yes.
president.
So you would
Yes.
agree that such image will have a sway on whether our nation will enter into agreement with us.
Sure.
Okay, so you therefore agree that a stable mechanism in treaty making and treaty withdrawal will encourage other states
Council,
to
it will be
enter
more
into
unstable if we
agreement
need the
with us.
Senate concurrence because there could be disagreements between the Senate and
Next
the president.
question. Yes
It's
or
more
no?
unstable.
Yes or no? Yes,
Yes
or
or
no?
no?
Are you impressing, Mr. Speaker, that other states will prefer or trust our country even with an autocratically dictated treaty without withdrawal mechanism?
That is speculative.
Okay. Is the president the government?
No.
Is the government the president?
No, but he's the chief architect of foreign
So
policy.
therefore, when you say representation of a country, it doesn't only pertain to the executive, correct?
No.
The power of our government is assigned to three
The
branches.
Senate represents
correct?
the people. The president
Yes or no?
represents us
Yes
in
or
the
no,
foreign
Council? It
relations.
is my
So
time
it's a
to
no.
ask. The power of our government is assigned into three branches, correct?
Sure.
So therefore, you cannot say that president is the government. Next.
Of course.
It is your position that foreign relations such as treaty withdrawal should be a political question because the president is an architect of the foreign affairs?
Sure.
That foreign affairs include treaty making as well as decision in entering to them, correct?
Sure.
So you would agree with me that treaty power of the president by express provision is limited through Senate concurrence, correct?
No.
Section 21, Article 7. And
Which
that
talks
exercise...
about entering into a treaty, not
Exactly,
withdrawal.
exactly. That's
Not
my
withdrawal.
question. That the exercise of foreign affairs...
Let's now hear what our judges have to say about our debaters. Attorney Siron, how did the affirmative side, the Mindanao State University, do?
First of all, I'd like to congratulate you guys for a job well done. Your arguments were clear and you were able to convey them very well, and you were also able to effectively cross-examine the other side. Congratulations.
And Attorney Lau, how did the negative side, San Beda University, do?
Thank you so much. That was incredible, and you were impeccable. And thank you for, making it count. It certainly wasn't a waste of my time, our time. This is a debate competition, and you were very responsive. You didn't leave anything on the table, which is very nice. And then you supported everything. And it was really nice that you pointed out the disanalogy between the two. That the granting of one power is not tantamount to granting the other. Conversely, that withholding one power isn't tantamount to withholding the other. And that was very clear. And you were able to see the points, to identify the issues. And I see such a bright future ahead of you guys. Congratulations.
And another thing interesting about this debate is that, like all our debates, they broaden the discussion on topics of national interest. And now let's hear from our chief adjudicator, Judge Samadan. Your Honor, who did you pick for best speaker?
Before I announce the best speaker, I want to say that I was very much impressed with the level of argumentation done by all of the participants. You all have sound and solid arguments. So congratulations once again. Maybe I am in the presence of future great lawyers tonight. Okay, so for the best speaker, he is no other than Mr. Chris Chualao Ferrios from the San Beda University. Congratulations.
And the school that won tonight's round.
I was surprised with the winner of tonight's debate because they had, for me, the more difficult proposition. So congratulations, San Beda University, for winning tonight's debate.
A big congratulations to San Beda University for winning the 7th elimination round of Season 15. Next week, we'll revisit some of the highlights of the previous debates, and we'll tell you which teams are advancing to the quarterfinals. We'll also find out which schools will be competing in our wildcard round. I'm Mike Yoreta. Thank you for watching.